there. All right, we're back on record on State versus Howard and Purser. The jury has been deliberating, and we received communication the jury has reached a verdict. Mr. Foreman? Okay, you can hand the verdict form to the clerk, please. Again. Things on my desk. It could be on. All right, Mr. Prosecutor, clerk, court will now read the verdict.
In the Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard, case number 21 CR 164. Verdict: count 1, engaging in a pattern of corrupt activity, revised code 2923.32A1. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of engaging in a pattern of corrupt activity in a first-degree felony, as he stands charged in count 1 of the indictment. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Kurtzman. Case number 21, CR 165. Verdict: count 1, engaging in a pattern of corrupt activity, revised code 2923.32A1. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher R. Kurtzman, guilty of engaging in a pattern of corrupt activity, a first-degree felony, as he stands charged in count 1 of the indictment. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict: count 2, aggravated trafficking in methamphetamine, Ohio Revised Code number 2925.03A1, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of aggravated trafficking in drugs, as he stands charged in count 2 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount less than 5 times bulk amount. We further find that the offense was committed in the vicinity of a juvenile. The Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Kurtzman. Case number 21 CR 165. Verdict: count 2, aggravated trafficking in methamphetamine, Ohio Revised Code number 2925.03A1, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher R. Kurtzman, guilty of aggravated trafficking in drugs as he stands charged in count 2 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. We further find that the offense was committed in the vicinity of a juvenile. On the Pleas Court, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number CR 21 CR 164. Verdict, count 3, aggravated possession of methamphetamine, revised code 2925.11, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant Wesley A. Howard guilty of aggravated possession of methamphetamine, as he stands charged in count 3 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than the 5 times bulk amount. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Person. Case number 21 CR 165. Verdict, count 3, aggravated possession of methamphetamine, revised code 2925.11, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant Christopher R. Person guilty of aggravated possession of methamphetamine, as he stands charged in count 3 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk. Common Pleas Court, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict, count 4, aggravated trafficking of methamphetamine, Ohio Revised Code 2925.03, A1, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant Wesley A. Howard guilty of aggravated trafficking in drugs, as he stands charged in count 4 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. We further find that the offense was committed in the vicinity of the school. Hyde County Common Pleas Court, State of Ohio versus Christopher R. Person. Verdict, count 4, aggravated trafficking in methamphetamine, Ohio Revised Code 2925.03, A1, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant Christopher R. Person guilty of aggravated trafficking in drugs, as he stands charged in count 4 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. We further find that the offense was committed in the vicinity of the school. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict, count 5, aggravated possession of methamphetamine, revised code number 2925.11, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant Wesley A. Howard guilty of aggravated possession of methamphetamine, as he stands charged in count 5 of the indictment. Further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Person. Case number 21 CR 165. Verdict, count 5, aggravated possession of methamphetamine, revised code 2925.11, alleged value $300. We, the jury, having been duly impaneled and sworn, find the defendant Christopher R. Person guilty of aggravated possession of methamphetamine, as he stands charged in count 5 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict, Count 6, aggravated trafficking of methamphetamine. Ohio Revised Code number 2925.03A1, alleged value $600. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howell, guilty of aggravated trafficking of drugs as he stands charged in count 6 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christian R. Kirchner. Says Christian.
Okay, that's what I'm saying. That was, Christian.
Case number 21CR165. Verdict, count 6, aggravated trafficking of methamphetamine. Ohio Revised Code 2925.03A1, alleged value $600. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher R. Kirchner, guilty of aggravated trafficking of drugs as he stands charged in count 6 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding the amount, the bulk amount, of less than 5 times the bulk amount. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21CR164. Verdict, count 7, aggravated possession of methamphetamine. Revised Code number 2925.11, alleged value $600. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of aggravated possession of methamphetamine as he stands charged in count 7 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Kirchner. Case number 21CR165. Verdict, count 7, aggravated possession of methamphetamine. Revised Code 2925.11, alleged value $600. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher R. Kirchner, guilty of aggravated possession of methamphetamine as he stands charged in count 7 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Kirchner. Case number 21CR165. Verdict, count 8, aggravated trafficking of methamphetamine. Ohio Revised Code number 2925.03A1, alleged amount $300. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher R. Kirchner, guilty of aggravated trafficking of drugs as he stands charged in count 8 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding a bulk amount but less than 5 times bulk amount. Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Christopher R. Kirchner. Case number 21CR165. Verdict, count 9, aggravated possession of methamphetamine. Revised Code 2925.11, alleged value $150. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher R. Kirchner, guilty of aggravated possession of methamphetamine as he stands charged in count 9 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21-1CR164. Verdict, count 10, aggravated trafficking of methamphetamine. Ohio Revised Code number 2925.03A1, alleged value $150. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of aggravated trafficking of drugs as he stands charged in count 10 of the indictment. We further find that the amount of methamphetamine used is equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Hyde County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict, count 11, aggravated possession of methamphetamine. Revised code 2925.11, alleged value $150. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of aggravated possession of methamphetamine as he stands charged in count 11 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. The Court of Common Pleas, Highland County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict, count 12, aggravated trafficking of methamphetamine. Ohio Revised Code 2925.0381. Alleged amount $680. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of aggravated trafficking of drugs as he stands charged in count 12 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount of less than 5 times bulk amount. Court of Common Pleas, Highland County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 164. Verdict, count 13, aggravated possession of methamphetamine. Revised code 2925.11, alleged value $680. We, the jury, having been duly impaneled and sworn, find the defendant, Wesley A. Howard, guilty of aggravated possession of methamphetamine as he stands charged in count 13 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 165. Verdict, count 14, forfeiture, 2005 Cadillac. We, the jury, having been duly impaneled and sworn, find that the 2005 Cadillac was derived from, directly or indirectly, or realized through conduct in violation of count 1 of the indictment, of which we have found the defendant guilty. Court of Common Pleas, Highland County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 165. Verdict, count 14, forfeiture, 2011 Ford Taurus. We, the jury, having been duly impaneled and sworn, find that the 2011 Ford Taurus was derived from, directly or indirectly, or realized through conduct in violation of count 1 of the indictment, of which we have found the defendant guilty. Court of Common Pleas, Highland County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 165. Verdict, count 14, forfeiture, 2011 Ford Jaguar. We, the jury, having been duly impaneled and sworn, find that the 2011 Jaguar was derived from, directly or indirectly, or realized through conduct in violation of count 1 of the indictment, of which we have found the defendant guilty. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Wesley A. Howard. Case number 21 CR 165. Verdict, count 14, forfeiture, 2008 Chevy Malibu. We, the jury, having been duly impaneled and sworn, find that the 2008 Chevrolet Malibu was not derived from, directly or indirectly, or realized through conduct in violation of count 1 of the indictment, of which we have found the defendant guilty.
Thank you, Mr. Hobson. All right, the court will note that each verdict form is signed by all 12 jurors. And I'd ask at this time, is this or each of these verdicts, the verdict of each and every one of the 12 jurors indicate at this time? So, okay. All right. And as to this is count 6, I believe it was that name Christian, we struck down and sort of Christopher, the body of St. Christopher, my mistake. I actually reviewed these again this morning and didn't catch that. But that court will take that up. amending or striking out Christian and right Christian count 6, so the caption would be really form of say for all others. All right, now, do either council wish to add or withhold?
Fail.
Your Honor, we approached before you use the jury bill.
Thank you. All right. Court, accept the verdict of the jury and will find the defendant guilty of each of the criminal offenses as set forth in the indictment. And as to the forfeiture against Lieutenant Howard, inclining to the 3 of the 4 people are set for forfeiture, being the town who set for. All right, ladies and gentlemen of the jury, this will complete your service. I want to thank you for your service and your attention during this the 2 days of trial. I know they are, especially after they were all day, and we obviously took time then this morning to consider everything and reach your verdict. So the court thanks you for that. And you will be getting your pay vouchers, and then if you need excuses for work, shows who are here. You'll have those for you as well. So if you can just look at this time, back to here, you'll be out of the office hands. You are released from your obligation now. You may speak if you wish, you do not have to, but you may speak with anybody about the case. Thank you. Everybody can make their
Thanks very much.
All right. The court has accepted the verdicts of the jury, discharged the jury. Court notes that several of these offenses, projecting count 1 are mandatory sentences. Court also notes that the 3 of 20 person as well does not have. But given the fact that these are mandatory offenses, given the overall evidence in the case, the court can proceed sentencing to order. So we'll start with your safety regarding sentencing for legal. So we may Mr. Collins.
Thank you, Your Honor. I'm not going to go back through the facts of this case with the court. Obviously, you sat here and heard it. I think the evidence is clear, overwhelming, that Mr. Howard was the dude in this case. Mr. Herschler has no prior felony history whatsoever. I'm not sure he has much of a criminal history, period. And I want to shed some further light on some things. Since, Your Honor, these two have been out on bail, Mr. Howard has not slowed down his business whatsoever. He just changed drugs. He currently is selling, or has been selling marijuana. We found out about this because we were working another case, and when we pulled Facebook stuff, Mr. Howard's dealings buying dope is on there. I'll also let the court know that when Mr. Debo left the court from testifying on Monday, he was yelled at outside. I myself have been followed and yelled at by Mr. Howard. I'll be honest with you, I can't remember prosecuting someone quite as arrogant as Mr. Howard has been. He truly made his living off selling drugs, and has been assisted by his family in that. I'll also let the court know that following things that happened in the past, his sister was able to connect with Mr. South. Mr. Howard was aware of that at the last trial, based on his own Facebook messages with his sister Brittany, and actually had the pictures of the questions and recordings of trial prep that Mr. South recorded and took pictures of and shared with Brittany, who then sent the pictures to Mr. Howard on Facebook. And then, despite the no contact order with his co-defendant, he then emailed them to Mr. Hertzler, or not emailed, rather, took pictures and sent them on Facebook to Mr. Hertzler. And if the court wants to take a recess, everybody's shaking their head no, but I'll go get it and we'll put it up on the big screen if the court's interested in seeing it. So, Your Honor, I think that the evidence was very clear that Mr. Howard was a supplier in this case, and that Mr. Hertzler was doing his bidding for him. Mr. Debo also said that Mr. Howard was his supplier, and then when it was time for him to buy a large amount of drugs, the first place he went was to Mr. Howard. And I think based on all of that, as well as Mr. Howard's prior criminal history, the fact that he admitted that he sells drugs in the November 1st deal, and that's how he pays for his cars and things of that nature, deserves a substantial prison sentence, term of incarceration. Thank you.
I should have asked this prior, so before I call the comment, that's of course, the opinion in counts 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 merged. Is there any disagreement with that statement?
No disagreement.
I'm sure there isn't. So based on that, those will merge. There's only one conviction, one sentence for both convictions. It states option to return under 1.5, I believe it is, murder statute 2 elect, which they wish to
re-elect the trafficking charges.
So those would be the even number counts. All right, so we'll set court sentence then on the even number counts involving the aggravated trafficking and not the aggravated possession. Okay, Mr. Mormon, on behalf of Mr. Howard.
Thank you, Your Honor. Obviously, you reviewed the facts in this case. You understand my client's criminal history, and my understanding is one prior felony. I would ask that you take into consideration the facts presented. Obviously, there was some information brought up in sentencing. As far as other allegations, my request is that you look at the facts that are in evidence, the testimony that you heard today. Clients, through this lengthy process, this is a longer one in Highland County, it's been compliant with pretrial, showed no negative screens. He's employed. We would ask that you take all that into consideration. The fact he has picked up new felonies during the pendency of this case, we would ask that you take that into consideration.
All right, on behalf of Mr. Person.
You know, throughout this matter, Mr. White and myself both got to know Chris quite well, I can say, as a defendant. He's done everything that was asked of him. He's shown up for every single appointment. My office never called in, never canceled one. The evidence was overwhelming here. The charges are serious. But as the court take into consideration, Chris is a married man. He's got three young children with no prior record. 4 children, Your Honor, I'm sorry. He's made all of his court appearances while he's been on bond. He has ties to, he originally hails from Texas. Been lots of conversations as to whether Chris would even be here for the trial since he had participated in the first trial in this matter, and he's shown up at every time. We'd ask the court to take all that into consideration.
right, Mr. Howard, say anything in room now?
No, for the end of the case, no, Your Honor.
Mr. Hertzler, anything you'd like to say?
Your Honor, thank you.
All right. Well, start with you, Mr. Howard, since you're the first case number on this report. The evidence is overwhelming that you are a very significant drug dealer, have been for a period of time. You make a living off selling drugs. While you did some of that, you did some of that. I mean, it's clear that this is what you did. Make money, and the court finds that you're a straight danger to this community, of that, and that you should receive significant prison time. And the law provides that count 1, count 2, count 4, that those are mandatory terms. So, with regard to count 1, the engagement in a pattern of corrupt activity, first degree felony, it is the order of the court to be and are hereby sentenced to a period of 10 years. And that is minimum mandatory that you must serve. That can be increased by up to 1/2 by the Department of Rehabilitation and Corrections. So it could end up being 15 years. As to count, and mandatory fine for that is $10,000, I believe. Actually, 20.
Yes.
Mandatory fine for 10,000. With regard to count 2, the court sentences you on that count to a term of 5 years. That is a mandatory minimum. It is subject to the 50% increase, but under the law, only one increase is provided. Maximum most serious of the 50% will be determined on count 1, not count 2. Even though the subject very close. And fine on that is mandatory fine of $75. That's close. Count 4, second degree felony, and the court imposes a sentence of 5 years for that. Which is again a mandatory sentence, and it also imposes a fine of $75. Count 6, third degree felony, court imposes a sentence of 18 months for that, and $5,000 mandatory fine. Count 10, third degree felony. Court imposes a sentence of 18 months and for a fine of $5,000. And count 12, a third degree felony. Court imposes a sentence of 18 months and for a fine of $5,000. Each of those sentences would be served consecutively to one another. Court finds that these offenses committed as a series of one or more series of conduct, ongoing conduct, that you're a significant drug dealer, making money. I can tell you in 46 years that I've been involved in law enforcement, 32 years overall in prosecuting, 14 years on the bench. I don't think I've ever seen a money counter. The whole time I've ever seen money counters and banks. So that tells me you are a huge drug dealer. And so it's clear that you need to be punished significantly. People want to take the risk of being a big-time drug dealer. As one attorney, legal attorney used to say, you take your money and you take your chances. You take your chances, and you're going to pay. And so those will be served consecutively. According to the sheriff, you had 2 days of jail time credit. That case actually had 3 days total jail time credit. Now, you're also ordered to pay the court costs, which you have to do that for first, may exclude other bank account rules or any other assets you may have, that does affect it, and complete your sentence, and in this end, you get credit for each hour you work in 907. Now, upon completion of your prison term, it will be mandatory that you be put under post-release control on count one. That have to help you out about it's 18 months, 3 years on two, what is it on one?
We don't have a form like this, Judge.
Now, what I have is outdated. You know what?
We need a sentencing form.
And there's going to be a period of post-release control. It's going to be mandatory, and we'll find out what it is here in a minute. The law change, and of course I have here, I'm sure I have that. I'm thinking that I know for that too, includes 18 months to 3 years. And 18 after 3 years, I forgot what it is, and I want to be honest with that in a moment. And what that means is, and that's count one, and count, that's the greatest. So that would be the one that will be determined, although on the F2s, it would be, I believe, 18 months to 3 years. On the F3s, it would be up to 2 years. But again, that's discretionary. With the F1, F1 is mandatory. There won't be any license suspension. Right. All right. Now, and with regard to the forfeiture of court orders and any interest in the vehicles other than the Malibu are ordered to be forfeited. It looks like I went out. That's a very short one.
For a first degree that is not a felony sex offense, will have no less than 2, but no more than 5 years.
And then F2 is 18 months to 3 years.
Yes.
So, Mr. Howard, you will be put under post-release control once you complete the prison term imposed by the court for a term of at least 2 years, up to 5 years, as determined by the APA. And if you violate and then about the other conditions that they set, if you violate any of those conditions during that period of time, you can return your prison, making sure condition free up to 9 months for a single violation up to a maximum of half your prison term for all violations. But if your violation is a felony, I'm sorry, you committed a felony on post-release control, then in addition to every sentence the judge in due case imposed by the head judge can also sentence you in this case to an additional period of 1 year or whatever time left on that period of post-release control, whichever is greater, for committing that new felony following post-release control in this case. All right. Now, with regard to you, Mr. Herschel, while I don't think that you're as big as a dude as Mr. Howard is, you certainly facilitated his conduct and were extremely involved with him and actively selling, making deals on their own, with as indicated in the testament. So it is a judgment of the court that you be sentenced on count one to a term of 8 years. Correction for section 7.1 of Ohio, that is a mandatory term, which can be increased by the Department of Rehabilitation and Corrections at their discretion to up to 12 years, but they can increase it by one half, so they could end up being as much as 12 years. On count two, you're sentenced to a term of 3 years. On count, that's mandatory. Count four, you're sentenced to a period of 3 years. Count 6, you're sentenced to a period of 3 years. As count 8, it was pointed out that after the orders were received and accepted, that the court inadvertently left off the additional finding. Count 8, none of the attorneys caught it, I didn't catch it. And so, that actually makes it a third degree felony, although it was indicted as a second degree felony. So that's, benefit to you. But on count 8, the, sentence will be, 18 months. All those sentences are ordered to be served consecutively with one another. And again, the court finds that your conduct is extremely serious and extensive, and it appears that you're drug dealer too, although not on the scale of Mr. Howard, below him, easily below him, but nonetheless a significant drug dealer. That is, second sentences in each of these cases are necessary because the conduct was a series of course of conduct in one single sentence would not adequately reflect the seriousness of conduct and crimes committed, and the sentences may both not disproportionate to the seriousness of the offense. For further comments, that it's necessary because of the criminal conduct shown in these cases that the public future crime by each. You are fined, Mr. Purser, you are also fined $10,000 mandatory fine on count 1. On count 2, that's $7,500 mandatory fine. On count 4, that is a $75 mandatory fine. Count 6 is $5,000. Count 8 is $1,000.
Your Honor, what sentence did the court impose for count 6 for Mr. Hertzler?
3 years. Oh, no, I'm sorry. On Mr. Hertzler, 18 months. 18 months. 3 years on counts 2 and 4. If I said 3, I wrote down 18 months,
Okay.
and that's what I intended to do. So I did say 3 to 18 months. So count 1 is 8, count 2, 4, 3, count 6 is 18 months, count 8 is 18 months. And again, the findings is just the second sentence, I just made a statement on the findings of these sentences. And according to the sheriff, we have 52 days in jail time. That. Now, upon completion of these, and again, as far as the count 1, the 8 years, as I said, is subject to increase to 12 by the DRC. They can also increase counts 2 or 4 under the law up to 50%, but because the law says, the code says it's only the most serious offense, that would be counted. On completion of the prison term, voted by the court, you will also be under mandatory post-release control as in count 1 for at least 2 years and up to 5 years of conditions set by APA. They determine if you fail to comply, they can return to prison and serve an additional period of up to 9 months and a single violation up to the maximum of half of prison term imposed for all violations but if committed felony. While the post-release control, then in addition to every sentence the judge in that new case imposed upon you, and can also sentence you to committing that offense under post-release control in this case with an additional period of 1 year and every time left on that period of post-release control failure is greater. That occurs, that has to be served consecutively sentence in the case. Also, if the court prosecutor judges granted an future order to not pay that, then the court will collect that to very painfully let the bank account wait to for that and that is collected. And upon completion of the prison term, the court could permit you to do service to the credit fee charge work in an hour way set up for fee charge work to reduce the judgment by that time. Unless you have something.
2 things, Judge. The first is just for permission to put in the entry for the titles, for the purchase titles to the Hyden County Commissioners.
All right, so
And the second is that we did seize $2,085 during the search warrant. That money was not indicted because Mr. Howard was already indicted at the time. The court wishes that to be ordered to pay for costs.
that would be paid to the cost, and if there's any excess, will be applied to mandatory fine and penalty. State have anything else?
State does not.
Anything else, Mr. Morgan?
Your Honor, just appellate rights.
All right,
Just appellate rights, Your Honor.
I will find that in a moment.
Nothing else, Your Honor.
Okay, anything else?
Only, Your Honor, Mr. Wagner and myself were appointed to represent Mr. Hertzler. I'm not sure if his financial status has changed with respect to the fines.
All right, fine. We'll see about that in the future. All right. Now, Mr. Hertzberg, Mr. Howard, you have each been found guilty and sentenced of the offenses as reflected here this morning. You each have a right to file an appeal of the convictions and the sentences. That appeal has to file within 30 days of the sentencing after being filed with the clerk, which will probably be either later today or tomorrow. You have a right to have the doc or all the record of proceedings, recordings and transcripts of those recordings, and all the documents that are required. You do not have the funds to pay for those. The court will provide them to you at cost. You also have the right to have an attorney to represent you on the appeal. And if you do not have money to hire an attorney, the court will appoint one for each of you at the cost. And I know it's on practice now that trial counsel does handle appeals, but I would ask trial counsel to reach out to talk with them if there's a specific appeal that you file those appeal for the purpose of that purpose. And Mr. Howard and Mr. Herzl will let the court know if you have the ability to hire your counsel for the purpose of being fill out a financial disclosure form, and on that court will appoint an attorney. But again, those appeal must be filed in 30 days, and the attorney must be transcripts must be. All right. Anything else? Right. All right. And there is your man in custody.
Step back to Chief. You got the Chief Stratton. After you go, step back here, please. Stand right here. Take your gun. Put your chest where you're starting to do there. See you. I appreciate it. Thank you, gentlemen.
So Brenda, Jersey.